Good morning. Today we're conducting the first Category 4 slot machine license auction in the round of auctions provided for in Act 20 of 2019. The winner of today's auction will obtain the right to select a Category 4 location. All persons eligible to submit a bid envelope and an affidavit location envelope should have checked in with the board secretary, Pam Lewis, and provided their 2 envelopes for placement in the appropriate boxes. Has everyone who is eligible to participate in the auction and who desires to place a bid today provided their bid envelope to Pam Lewis? And if you haven't done so, would you please do so immediately? Having received no responses, this auction is canceled. Pursuant to the provisions of the Act, there will be no future auctions, and we'll now proceed to the board meeting. I do my joke. They're all legislative.
Hello?
Sean? Commissioner?
Yes,
You're on.
thank you.
Good morning, everyone. I'm David Barish, Chairman of the Pennsylvania Gaming Control Board. If you haven't already, I'd like everybody to make sure to put their electronic devices on silent. With us today, Fred Strathmeyer from the Department of Agriculture representing Russell Redding, Jen Langen representing Joe Torsello, the State Treasurer, and Kristen Heidingsfelder representing Secretary of Revenue Dan Hassel. Thank you all for your continued involvement and interest. Quorum being present, I'll call the proceedings to order. First order of business, Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. By way of announcements, the board held an executive session yesterday on Tuesday, September 3rd, to discuss personnel matters, to conduct quasi-judicial deliberations relating to matters coming before the board today. Given what I was going to say, the board will hold its next Cat 4 auction on September 18th, but in view of the fact that we had no bids today, that further auction is no longer on the schedule. Correct, Mr. Sherman? Is that correct? Thank you. And before we begin, I would note that participating by phone is Commissioner Sean Logan, who's out in Pittsburgh this morning. Good morning, Sean.
Good morning, Mr. Chairman.
Okay. Next, we have consideration of a motion to approve the minutes and transcripts of the July 10th, 2019 meeting. May I have such a motion?
Mr. Chairman, I move that the board approve the minutes and transcript of the July 10th, 2019 meeting.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Next, Danette, Personnel, or should I say Director of Human Resources.
Good morning, Chairman, board members.
The Office of Human Resources has one motion for your consideration today relative to the hiring of one individual. Christopher Schroeder has been selected as the Director of Casino Compliance. He has completed the interview process, background investigation, and drug screening, and is recommended for hire by Executive Director Kevin O'Toole. Unless you have questions, I ask that the board consider a motion to approve the hiring action as indicated.
Are there any questions or comments on the board about this matter? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the applicants for hire as proposed by the Human Resources Director.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you.
Thanks a lot, Danette. Dave Wren, Office of Financial Management.
Good morning, Chairman and fellow board members. I'm here today to provide a final accounting of expenditures for fiscal year 18-19, which concluded June 30th. For the fiscal year, expenditures totaled $41.6 million and revenues totaled $43.8 million. This means that there's a revenue surplus of $2.2 million, and this money will lapse back to the 1401 operator assessment accounts. For the year, overall expenses increased by $2 million, slightly over 5%. Personnel expenses were $36.1 million and accounted for 87% of the overall expenses. Personnel expenses were divided between salary expenses of $20.2 million and benefits totaling $14.8 million. Benefits as a percentage of salary expenses were 69%. This is the same rate as it was in the prior fiscal year. Personnel expenses were $1.7 million higher than in fiscal year 2017-18. This is due to contractual management salary increases and increased complement levels due to expanded gaming. Operating and fixed asset expenses totaled $5.5 million. This was $300,000 higher than in the prior year. Again, much of this increase was due to higher travel and investigative costs related to gaming expansion and increased interagency billings for services billed by state agencies to the board. 80% of overall operating expenses were for rentals and leases, services such as interagency billings and fingerprint checks, and other operating expenses, which includes database checks utilized in background investigations. That concludes my report.
Any questions or comments from the board for Mr. Wren? Hearing none, thank you very much, David. They have a motion? No, there is no motion here. Thank you. Office of Chief Counsel. There's nothing to-
Good morning, Chairman, members of the board. First, I have to say, being called up to do the auction, having nobody shows up feels like the minor league pitcher that was called up to make their major league debut in the last game of the season, only to have it rained out and canceled.
Well, I hope you don't take it personally.
No, not at all. Our first agenda item relates to a proposed regulation, which Assistant Chief Counsel Chad Zimmerman is here to present.
Good morning, Chairman, other commissioners of the board. Before you is proposed rulemaking number 125-225, which is a proposed rulemaking regarding amendments for the compulsive and problem gaming regulations and the self-exclusion. The necessity of these was precipitated by the expanded gaming, which created additional self-exclusion lists. The amendments to the regulations involve the rebranding or renaming of the list that was previously the self-exclusion list to the casino self-exclusion list, and amendments were made to reflect that change. Additionally, provisions were added to the regulations that that allow for an individual who has self-excluded for lifetime to seek removal from the self-exclusion list after a period of time and meeting other conditions, and then also provisions to allow an individual to self-exclude and remove themselves from self-exclusion online on a portal that will be set up by our IT office. If there are any questions, I can answer them now. If not, I would ask for a motion to approve the regulations.
Are there any questions for Councilor Zimmerman? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the proposed regulation number 125-225 as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you.
Thank you, Chad.
Next, the board has two petitions before it for consideration. The petitions will be decided based upon the documentary record by agreement of the parties. In each of the matters, the board has, in advance of this meeting, been provided with all documents filed of record. The first matter is Roman Mosaic and Tile Company's petition for removal from the board's prohibited gaming service provider list. In December 2006, Roman Mosaic and Tile Company submitted a gaming service provider application, and during the application process, the Bureau of Licensing contacted the company's president, Paul Trevisan, informing him that the company had not submitted several key employee qualifier applications as required. The individual never complied with the request to submit the applications, and the company was then placed on the prohibited gaming service provider list. Roman Mosaic and Tile Company's petition requesting removal from that list claims that Mr. Trevisan is no longer working for the company, and that the current corporate officers will provide whatever information is required to complete the application process. The Office of Enforcement Counsel does not object to the petition to remove the company from the list, so long as the company submits the appropriate completed forms to the Bureau of Licensing, pays any associated fees owed to the board, as well as a $1,500 penalty. That matter is now appropriate for the board's consideration of a motion.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grants Roman Mosaic Tile Company petition to remove from the prohibited game service provider list with the conditions described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The second petition before the board is Joseph Ravello's petition for removal from the involuntary exclusion list. In October of 2015, the board placed Mr. Ravello on the involuntary exclusion list after it was shown that in March of 15, while gaming at Harrah's Philadelphia, he pass posted one bet, winning $750 to which he was not entitled. Mr. Ravello was criminally charged and permanently evicted from Harrah's. He pled guilty in criminal court and has made full restitution to Harrah's, as well as completed his probation period. Almost 4 years have expired, and Mr. Ravello is petitioning for removal from the exclusion list. The Office of Enforcement Counsel has no objection to the request and would be appropriate for the board to consider a motion.
Just one question, a procedural question. While we can take them off the list or not take, assuming we take them off the list, may a casino still keep him out?
Yes, that's their prerogative as the owner of that private
So
property.
this doesn't
to
entitle him to necessarily enter into the casino where he was barred?
Correct. Harrah's could maintain their permanent eviction.
Are there any other questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant Joe Ravello's petition for removal from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next, we have withdrawals and surrenders, as well as reports and recommendations presented by Deputy Chief Counsel Steve Cook.
Morning. The board has received several unopposed petitions to withdraw the applications or surrender the credentials of the following individuals and entities: Nathan Wads, Eugene Davis, Jeremy Cantor, Exalis Investments, SAS, Hestia Development, Holdings Wilson, S.A., Charles Henry, Elaine Corrett, Kevin Brown, Terrence Wright, Neil Sell, Michael Bryant Polk, Pia Lena Olofsson, William Bible, Joshua Risley, Aaron Chamberlain, PaySafe Payment Services, LLC, and William Ambrose Burke. The Office of Enforcement Counsel has no objections to any of these requests, and as a result, if the board grants them, they'd be doing so without prejudice to each of these parties.
Any questions or comments from the board on this matter? Hearing none, may I have a motion?
Mr. Chairman, I move the board issue orders to approve the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next before the board for consideration are 6 reports and recommendations received from the Office of Hearings and Appeals. These reports and recommendations, along with the complete evidentiary record, have been provided to the board in advance of this meeting, and additionally, each person that is the subject of these reports and recommendations has been notified that the board would be taking their matter up today. If any of these persons are present and wish to address the board, they should come forward when their name is called or initials are called. The first report and recommendation before the board pertains to a request for removal from the self-exclusion list. Pursuant to the findings of fact in the report and recommendation issued in this matter, on March 31st, 2011, an individual with the initials DC entered the Hollywood Casino at Penn National Racecourse and requested to be placed on the self-exclusion list. The casino compliance representative who placed the DC on the list testified that he conducted the mandatory interview, explained the process of being placed on the list, the consequences of the exclusion period options, and completed all of the required paperwork and procedures. Thereafter, DC signed an acknowledgement form selecting lifetime self-exclusion. On September 20th, 2018, DC filed a request for removal from the lifetime self-exclusion list. The Office of Enforcement Counsel filed an answer objecting to that request. A hearing was held on February 27th. OEC appeared presenting testimony and documentary evidence. DC appeared and testified on his own behalf, and his wife also came with him and testified on his behalf. DC admitted to signing the self-exclusion documents and placing himself on lifetime self-exclusion, as well as placing himself on exclusion lists in the states of New Jersey and Delaware for lesser periods of time. He has since removed himself from both the New Jersey and Delaware lists. Additionally, DC states that he is in control when he gambles, and his wife testified that both she and DC frequent casinos in Delaware, and they wish to begin frequenting casinos in Pennsylvania again, and basically that the impetus of his placement on the lifetime self-exclusion list were marital difficulties that the couple was having at the time. Ultimately, after hearing all of the evidence presented, the report and recommendation issued subsequent to the hearing found that DC is not eligible for removal from the lifetime self-exclusion list under the board's present regulations. However, it should be noted that the board today started the process of amending its regulations to allow for a petition process whereby a person who chooses lifetime self-exclusion can petition for removal after 10 years and has passed, and as long as certain conditions are met. In this case, this would allow DC to petition for removal from the list anytime after March 31st, 2021, if in fact that regulation that the board voted on today passes into final form prior to that date. With all that being said, this matter is now ripe for the board's consideration.
Thank you, Steve. Are there any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding DC's petition for removal from the voluntary self-exclusion list as described by the Office of Chief Counsel. If proposed regulation number 125-225 is ultimately promulgated in final form, DC may again petition the board for relief after March 31st, 2021.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter before the board pertains to a second request for removal from the voluntary self-exclusion list. On September 25th, 2018, an individual with the initials DF appeared at the board's Conshohocken office and requested to be placed on the board's self-exclusion list for a period of 5 years. 5 months later, DF filed a petition for removal from the list. The Office of Enforcement Counsel filed an objection to that request. A hearing was held before the board's Office of Hearing and Appeals on May 14th, 2019. Both Enforcement Counsel and DF appeared at that hearing. The evidence presented at the hearing established that on September 25th, 2018, DF's wife drove him to the Conshohocken office where he met with an administrative assistant regarding placement on the self-exclusion list. The administrative assistant testified that she conducted DF's self-exclusion interview, that DF had signed a form giving his wife permission to be present during the interview, and that he was not being coerced. Additionally, the assistant testified that all the required paperwork and procedures were followed during the interview, and that DF signed the exclusion paperwork, choosing a 5-year period of self-exclusion. Moreover, at one point during the interview process, DF's wife was asked to leave the room so as to allow our staff member the opportunity to question DF and to be assured that he was not in fact being coerced into placement on the list. When given an opportunity to present evidence, DF testified that he was upset the day he placed himself on the list due to recent losses gambling. He stated that he wanted to choose a one-year option but felt pressured by his wife to pick a longer exclusion period, and that our staff person recommended a 5-year term as a compromise. During the assistant's testimony on that issue, she stated she had never pushed, she didn't push DF into choosing a period, nor has she ever pushed anyone into choosing a period of time for self-exclusion. Ultimately, after hearing all the evidence, the report and recommendation issued by the hearing officer recommends that DF remain on the list for at least the 5-year term.
Are there any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding DF's petition for removal from the voluntary self-exclusion list as described by the Office of Chief Counsel, and that DF remain on the self-exclusion list.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next report and recommendation before the board is a third request for removal from the board's voluntary self-exclusion list. Pursuant to the findings of fact in the report and recommendation issued in this case, on July 16, 2017, an individual with the initials JJ entered Presque Isle Downs and requested to be placed on the self-exclusion list. The casino compliance representative who placed JJ on the list testified that he conducted the mandatory interview, explained the process of being placed on the list, and the consequences of the exclusion period options. In doing so, he followed or completed all the appropriate paperwork and followed all the procedures. Thereafter, JJ signed an acknowledgement form selecting a 5-year period of self-exclusion. On February 4th, 2019, 19 months into the selected 5-year term, JJ filed a request for removal from the self-exclusion list, and the Office of Enforcement Counsel filed an answer objecting to that request. A hearing was held on April 30th, 2019. Both parties, OEC and JJ, appeared and provided evidence. JJ testified that on the day she'd placed herself on the list, she had been taking medication, drinking, and dealing with some personal issues at that time. JJ additionally stated she would have never chosen a 5-year period and believed that she had only chosen a 1-year period. During his testimony, the CCR that went through the process with JJ testified that she appeared sober and coherent, and in fact signed paperwork that she was not under the influence of alcohol or drugs. After hearing all of the evidence presented, the hearing officer recommends that JJ remain on the list for the 5-year period.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding JJ's petition for removal from the voluntary self-exclusion list as described by the Office of Chief Counsel, and that JJ remain on the self-exclusion list.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next report and recommendation before the board today pertains to Stephen Vislaki. In February of 2019, the Office of Enforcement Counsel filed a petition requesting that Mr. Vislaki be placed on the board's involuntary exclusion list, alleging that on June 10, 2018, while gaming at Mohegan Sun Pocono, Mr. Vislaki, who was intoxicated, became disruptive and combative. Specifically, when a beverage server informed him that staff was cutting off alcohol service to him, he became angry and agitated, ultimately pulling a box cutter out of his pocket and pointing it at several casino employees. He was charged with simple assault, harassment, and disorderly conduct, ultimately pleading guilty to disorderly conduct. A hearing in this matter was held on April 16, 2019, and then continued on May 16, 2019 at the request of Mr. Vislaki. Both parties appeared at the hearing, providing evidence. Ultimately, Mr. Vislaki testified that he pulled the box cutter out when a security employee put his hands upon Mr. Vislaki because he thought he was being robbed rather than security attempting to deal with the situation. After hearing all of the evidence presented, the hearing officer recommends that Office of Enforcement Counsel's request for placement of Mr. Vislaki on the board's involuntary exclusion list be granted.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopts the report and recommendation issued by the Office of Hearing and Appeals regarding the replacement of Stephen Vislaki on the PGCB involuntary exclusion list described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter to be heard by the board is the report and recommendation pertaining to David Mizak. Mr. Mizak holds a non-gaming employee registration and had worked at as an amphitheater cashier at the Rivers Casino. On June 17, 2019, the Office of Enforcement Counsel filed a request for an emergency suspension of Mr. Mizak's non-gaming registration after receiving notice that he'd been charged with a felony, 2 misdemeanors, and several summary offenses. Specifically, on May 27, 2019, Mr. Mizak, who was driving, struck a police cruiser and then attempted to flee the scene of the accident. A pursuit ensued, eventually ending by Mr. Mizak being pulled over. Upon a search of the vehicle, a small amount of marijuana was found, and Mr. Mizak was found to be under the influence of alcohol. A hearing in this matter was held on June 28th. OEC appeared, offering evidence supporting the facts as I just stated them. Mr. Mizak did not appear at the hearing, so he had no mitigating evidence put into the record. After hearing what was presented, the hearing officer recommends that the suspension of his permit continue. I would note the criminal charges remain pending.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopts the report and recommendation issued by the Office of Hearing and Appeals regarding the suspension of David Mizaki non-gaming employee registration as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The final report and recommendation before the board today pertains to William Maley. In April of 2018, Mr. Maley applied to obtain a gaming employee occupation level 2 permit, or a G2 permit as we call it typically, to work as a cage supervisor in the Lady Luck Casino, Nemacolin. Thereafter, on February 19, 2019, the Office of Enforcement Counsel issued a notice recommending denial of Mr. Maley's application based upon a 2006 criminal conviction and his conduct while employed at the Meadows Casino a year or two earlier. A hearing in this matter was held on May 2, 2019. Both OEC and Mr. Maley appeared and offered evidence. The evidence presented showed that Mr. Maley had a 2006 criminal conviction when he was 21 years old, which stemmed from his using another person's credit card without that individual's consent. However, the evidence also showed that BIE and the Office of Enforcement Counsel was aware of this criminal record after it was disclosed by Mr. Maley when he applied for and received a non-gaming registration in 2007 and a gaming employee permit in 2017. Relative to Mr. Maley's conduct at the Meadows in 2016, Enforcement Counsel sought to revoke Mr. Maley's non-gaming registration after it was thought he was pocketing money from restaurant bills issued to customers. After hearing in the matter, however, the Board's Office of Hearings and Appeals found that Mr. Maley was simply remiss in following the policies and procedures for opening customer checks, and there was no unlawful monetary gain made by him through his actions. As a result, the Office of Hearings and Appeals in that matter recommended that he keep his registration. The Board subsequently voted to agree with the hearing officer, and Mr. Maley kept that registration. After hearing all of the evidence presented in this case, the report and recommendation issued by the hearing officer recommends that OEC's request that the G2 permit be denied should itself be denied, and that he should be granted a G2 application, or G2 permit, I'm sorry.
Thank you. Are there any questions or comments? Hearing none, may I have a motion?
Mr. Chairman, I move the board adopt the report and recommendation issued by the Office of Hearing and Appeals as described by the Office of Chief Counsel, and that Mr. Maley be issued a G2 employee occupation permit.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
And that concludes the matters of the Office of Chief Counsel.
Thank you very much. Good morning, Sue.
Good morning. Thank you, Chairman Barish and members of the board. Before the board today will be 9 video gaming terminal establishment licenses and 1 interactive gaming manufacturer license. In addition, there will be 831 principals as well as key gaming and non-gaming employees. Finally, there will be the consideration of 5 registered gaming service provider applicants. First before you are VGT establishment licenses for establishments operated by CHR Corp. doing business as Rudders and TA Operating LLC doing business as Travel Centers of America. VGT establishments are truck stops seeking to place VGTs in their businesses. All of the VGT establishments were previously conditionally licensed. The Bureau of Investigations and Enforcement has completed its investigations, including evaluation that the applicants meet the VGT establishment eligibility criteria. The Bureau of Licensing has provided you with background investigation and suitability reports. Once fully licensed, an establishment can continue forward toward completing the steps necessary to commence VGT gaming. I've provided you with draft orders and ask that you consider the orders to approve first the VGT establishment licenses for CHR Corp. doing business as Rudders. The establishments are Store 4, which is located at 201 Cool Springs Road in Wrightsville, York County, Store 8, located at 129 Leader Heights Road in York, York County, and Store 56, located at 368 Lewisberry Road, New Cumberland in Cumberland County.
Are there any?
Enforcement Council has no objection.
Thank you. Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the video gaming terminal establishment licenses for CHR Corporation doing business as Rudders Stores Number 4, Store Number 8, and Store Number 56 as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next are VGT establishment licenses for TA Operating LLC doing business as Travel Centers of America. The establishments are Site 67, located at 5644 State Route 8 in Harrisville, Butler County. Site 3, located at 245 Allegheny Boulevard, Brookville, Jefferson County. Site 68, located at 5600 Nittany Valley Drive in Lamar, Clinton County. Site 212, located at 6 Buckhorn Road, Bloomsburg, Columbia County. Site 213, located at 10835 John Wayne Drive in Greencastle, Franklin County. And Site 214, located at 875 North Eagle Valley Road in Milesburg, Center County.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the video gaming terminal licenses for TA Operating LLC doing business as Travel Centers of America for sites number 67, 3, 68, 212, 213, and 214 as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
In addition for your consideration is an interactive gaming manufacturer license for Ainsworth Game Technology. Ainsworth Game Technology is currently licensed in good standing as a manufacturer with the board. Under the Gaming Act, the board may use an abbreviated process to consider the application of an already licensed manufacturer. The Bureau of Licensing, Office of Enforcement Counsel, and Bureau of Investigations and Enforcement have reviewed the application and the status of Ainsworth Game Technology as a licensee, and I've provided you with the results of those reviews. I have also provided you with a draft order for Ainsworth Game Technology and ask that you consider it for licensure.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the abbreviated interactive gaming manufacturer license for Ainsworth Game Technology as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also for your consideration are principal licenses. Prior to this meeting, the Bureau of Licensing provided you with a proposed order for 2 principals. I ask that the board consider the order approving these licenses.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grants the principal employees licensing as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
There are also temporary licenses for your consideration. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 3 principals and 3 key employees. I ask that the board consider the order approving these licenses.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Additionally, there are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 566 individuals to whom the Bureau has granted temporary or full occupation permits, and 190 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the Board consider a motion approving the order.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the Board grant the gaming employee occupation permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
There are also recommendations of denial for 3 gaming applicants and 1 non-gaming employee applicant. The applicants were notified that they were being recommended for denial and failed to request a hearing within the specified timeframes. The Bureau of Licensing has provided you with orders addressing each of the applicants who the Office of Enforcement Counsel has recommended for denial. I ask that the Board consider the orders approving these denials.
Enforcement Council continues to request denial in each instance.
Thank you. Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the Board deny the gaming and non-employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
In addition, for your consideration are withdrawal requests. In each case, the license, permit, or registration is no longer required. For today's meeting, I've provided the Board with a list of 60 gaming employees and 3 non-gaming employees. I ask that the Board consider the order approving the list of withdrawals.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the Board grant the withdrawal of a key employee gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Finally, for your consideration are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 5 registered gaming service provider applicants. I ask that the Board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the Board approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
That concludes the matters of the Bureau of Licensing.
Thank you, Susan. Cyrus.
The Office of Enforcement Council will present 5 matters today for the Board's consideration, in which we will request the Board's approval of 1 revocation and 4 involuntary exclusions.
Good morning, Chairman Barish, members of the Board. David Tepper, TEPPER, with the Office of Enforcement Counsel. The next item on the agenda is an enforcement action seeking the revocation of Ashley Watts' non-gaming employee registration. While employed as a food and beverage attendant at Parks Casino, Ms. Watts stole at least $294.30 from Parks Casino by placing money in her pocket instead of her cash register. Ms. Watt was terminated by Parks and does not work for any slot machine licensee in Pennsylvania. Ms. Watt was properly served with the enforcement action seeking the revocation of her non-gaming employee registration and related request for default judgment. She did not reply to either pleading. Pursuant to Board regulations, all facts alleged in OEC's enforcement action are deemed admitted, and at this time, the Office of Enforcement Counsel requests that the Board revoke the non-gaming employee registration of Ashley Watt.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the Board approve the revocation of Ashley Watts' non-gaming employee registration as requested by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The remaining matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth and are licensed gaming therein. In each instance, the petition for exclusion has been filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in the petition. The individual named in the petition failed to respond within 30 days as required by Board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment in each instance and properly served the same upon each named individual. Therefore, all facts in each petition are deemed admitted. All filed documents have been provided to the Board, and the matters are presently ripe for the Board's consideration. In each instance, if the Board orders a proposed exclusion, each individual's photo, personal identifiers, and a summary of their inimical conduct will be placed on the Board's public website.
Next on the agenda is a request to place Kumachandra Bharat on the involuntary exclusion list. While a patron at Parks Casino, Mr. Bharat stole $900 worth of chips from the poker cage. As a result of his conduct, Mr. Bharat was criminally charged, and at this time, the Office of Enforcement Counsel requests that the board add Kumachandra Bharat to the board's involuntary exclusion list.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Kumar Chandra Bharat to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next on the agenda is request to place William Ortiz Jr. on the involuntary exclusion list. While a patron at Parks Casino, Mr. Ortiz stole a voucher worth $237.50 that belonged to another patron. As a result of his conduct, Mr. Ortiz was criminally charged. At this time, the Office of Enforcement Counsel requests that the board add William Ortiz Jr. to the board's involuntary exclusion list.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve the addition of William Ortiz Jr. to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next on the agenda is a request to place Rosetta Stewart on the board's involuntary exclusion list. While a patron at Parks Casino, Miss Stewart stole a voucher worth $240.86 from a patron's jacket pocket while the patron was seated at a slot machine. At this time, the Office of Enforcement Counsel requests that the board add Rosetta Stewart to the board's involuntary exclusion list.
I have a motion.
Mr. Chairman, I move that the board.
Excuse me. Are there any questions or comments from the board? Hearing none, may I have a motion?
Thank you, Mr. Chairman. Mr. Chairman, I move that the board approve the addition of Rosetta Stewart to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Good morning, Thomas Monahan, M-O-N-A-G-H-A-N, with the Office of Enforcement Counsel. The final matter on the agenda for the board's consideration is a request to place Nicole Jones on the board's involuntary exclusion list. On February 26, 2019, Ms. Jones left her two children, ages 5 and 3, unattended in a hotel room while she gamed at the Sands Casino. The children were left unattended for approximately 2 hours and 42 minutes before they were discovered wandering the hotel hallway. Ms. Jones was charged by Bethlehem Police for her actions. At this time, OEC requests that the board place Nicole Jones on the board's involuntary exclusion list.
Questions or comments from the board? Hearing none.
Mr. Chairman,
Yes, sir.
wasn't there another relative in the hotel room next door?
Mr. Monahan, could you?
I believe her father was in the next hotel room, if I'm not mistaken.
But was he?
Can we amend that to include him?
No, we have to file a separate petition.
Can I request that you file a separate petition?
He was not involved in the matter. I'll take it into consideration, but I can't
He's the
guarantee.
grandfather, but do you think he just by happenstance showed up that night?
No, I think he was staying in the room next door.
Okay, tell me how to formally request that you look into it.
We'll look into it.
Thank you.
Okay. Thank you, Sean.
Thank you.
Any other further questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Nicole Jones to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
That concludes our business.
Thank you. Today, we have a public comment period. As I understand it, no one has registered to speak today. Is there anybody else here? If not, I'll move on. I guess that concludes our business today. Next public meeting will be held on Wednesday, October 2nd at 10 a.m. in this room. As indicated earlier, that will be at October 2nd. As I said earlier, the second Category 4 auction that had been scheduled for September 18th has been canceled based upon the failure to have a bid this morning on the first one. May I have a motion to adjourn the meeting?
Mr. Chairman, I make a motion we adjourn.
Second.
All in favor?
Aye.
All opposed? The motion's adopted and we are adjourned. Thank you.